welcome back to another thrilling episode of our podcast, the Crystal Beam Podcast. It feels just like yesterday. We embarked on this incredible journey together, and today promises to be no less exciting. In this highly anticipated segment, we are diving into that same topic that you all have been waiting for, the Rivers political and legal matter at the Supreme Court. A saga we aptly titled The Supreme Court Decides. Yes, the other day we spoke on the matter, but today we promise to bring you something different because we are going to be, our host is going to be none other than Godspower Egbule, a public affairs analyst and a legal practitioner resided in Rivers State, Nigeria. As we explore the case, we can also look at the issues, the contending issues. So, on the February 10, 2025, the Supreme Court sat on, I think, about 6 appeals. One of the major appeals was that filed by the state governor and the Rivers State government, challenging the appeal court's decision on the judgments given by Justice Kayode Omotosho at the Federal High Court. While after that ruling, where the court governor's lawyers had to withdraw their appeal, very many people came up with the opinion that that withdrawal means that the case was already statute barred. Some say it was overtaken by events, that is the budget of 2024, which was one of the contentions or one of the orders made by Justice Omotosho. Well, I think that another section says no. To the contrary, once a matter, a court, competent jurisdiction gives its judgment, it remains valid until a court, a higher court, invalidates it. In today's segment, we are going to be talking about that, and we have Godspower Egbule, who is going to let us know what actually this means and what it pertains for Rivers people, the Rivers State government, and even the Rivers State House of Assembly. Just stay back, relax, and watch. Well, like I said, the governor of Rivers State had withdrawn his appeal in appeal numbers SCCV 1071-2024. That's the appeal from the judgment of Justice J.K. Omotosho in suit number FHC ABJ 1613-2023, wherein the court ruled that Governor Sim Fubara should present the 2024 budget to the House of Assembly, led by Right Honorable Martin Amaewhule. Well, the governor withdrew his appeal, and so people feel that he's bound by the judgment of Justice Omotosho and the judgment of the Court of Appeal. Well, some say, particularly those on the side of the governor, say it does not really matter because that budget of 2024 has been overtaken by events, as they are already operating the budget of 2025, which again was passed by a 3-man assembly. Well, as we look into the matter today, we are going to see the rightness or the wrongness, as the case may be. Thank you for joining us. Yeah, welcome to the program, Barrister Godspower Egbule.
The Amazon is always my pleasure being here.
You're welcome. We've been chasing you for a while, for a long while now. Thank you for, being our guest today.
Thank you.
Please, we would like to know what exactly is going on as it affects the legal and the political crisis rocking the state, particularly with the latest Supreme Court ruling on the matter.
Well, first of all, let me say that the courts exist to allow parties to ventilate their grievances. And when a party takes the other person to court, the court gives a judgment. Either party who may not be okay or may have reservations about that judgment appeals to the Court of Appeal.
Okay.
And depending on who wins, the other person exercises his own right of appeal and appeal to the Supreme Court.
Yeah.
There are a lot of contending issues in Rivers State with respect to the judgment of Honorable Justice Omotosho. You would recall that matter started on the 29th of November 2023, wherein Right Honorable Martin Amaewhule, as a speaker, of the River State House of Assembly approached the court for several reliefs. Number one was to stop the National Assembly from taking over the activities of the House of Assembly, because then too, Edison Ehie had declared himself as a speaker. And when there is any controversy making it practically impossible for the House of Assembly to sit and transact business, the National Assembly can take over. So Right Honorable Martin Amaewhule approached the Federal High Court to stop the National Assembly from taking over the activities of the River State House of Assembly, to stop the governor from transferring the clerk of the River State House of Assembly because it's not within his power. The other one was to stop the governor from stopping money standing to the credit of River State House of Assembly. Then all these matters were pending. Now, in the course of that matter, on the 12th of December 2023, the governor now presented that 2024 budget before Edison Ehie. On the 15th of December 2023, the Right Honorable Martin Amaewhule filed a motion before the Federal High Court and asked the Federal High Court to set aside the budget that was presented and passed by Edison Ehie and the Governor Sim Fubara. Now, in the course of the judgment, the Federal High Court, led by Honorable Justice Omotosho, granted the reliefs sought by Right Honorable Martin Amaewhule because the governor had withdrawn his processes and Edison had resigned his position as a member of the House of Assembly, which meant he was no longer a party to that suit. So in the course of delivering judgment and granting the reliefs sought by Right Honorable Martin Amaewhule, the court also delved into the budgets passed by the governor and Edison Ehie and nullifying that budget. And one of the important orders that Honorable Justice J.K. Omotosho made was to restrain the governor from making any requests, any presentation before any other House of Assembly, including nomination, to any other House of Assembly other than the one led by Right Honorable Martin Amaewhule.
Oh, it was an order of the court?
Yes, that was an order of...
It's one of the orders?
Yes, of Honorable Justice Jacob Omotosho. Do not make any nomination, do not make any request, do not make any kind of demand to any other House of Assembly other than the one led by Right Honorable Martin Amaewhule. Now, the governor exercised his right of appeal, an appeal to the Court of Appeal. The Court of Appeal quashed, dismissed his appeal, and upheld the judgment of Honorable Justice Omotosho.
The entire judgment?
Yes, the entire judgment of Honorable Justice Omotosho. Now, the governor now also exercised his right of appeal to appeal to the Supreme Court. But interestingly, the governor now, on the 6th of February, even before the date of the hearing, now withdrew his appeal. Meaning that the judgment of Honorable Justice J.K. Omotosho and that of the Court of Appeal with respect to that judgment stands. So, and you see, there has been a lot of misconception, or I don't know if I'll call it deliberate mischief, about what's happening. Now, some people say that matter was withdrawn because it has been spent. Now, there has been a lot of misinformation with respect to the judgment of Honorable Justice Jacob Omotosho that was upheld by the Court of Appeal. And that is to say that the matter before the Supreme Court has become spent. But you see, the matter before the Supreme Court was not just about the 2024 budget. In any case, Section 120 of the Constitution provides that the governor cannot make any spending from the Consolidated Revenue Fund of River State without an approved appropriation law. So, by withdrawing his appeal, what the governor has done is that the governor has conceded and indeed agreed that he spent money standing to the credit of River State government without a budget. And that itself is gross misconduct. So the consequences of the Supreme Court, the governor withdrawing his appeal before the Supreme Court and dismissal by the Supreme Court are indeed enormous. And I pray that the governor will come to the realization of the consequences of his actions, because one way or the other, the Supreme Court would have determined the matter. And all we can do is to hazard the judgment of the Supreme Court. But on that day, the Supreme Court would give a judgment, and nobody knows where that judgment will tilt towards.
Yeah, but don't you think it was strategic for them to have withdrawn so that the merits of the matter, the Supreme Court won't deal with the merits of the matter? Because that's part of their argument. Those who are defending the governor, they say it was a strategic move, aimed at stopping it. And of course, they said the 2024 budget had expired, so there was no need for the appeal. But again, I don't have a copy of that appeal by the governor, but I'm sure it's not just he was not only appealing against the issue of the budget 2024. I think it's all about the judgment of Omotosho, which you have also x-rayed. And so now, what does this really, we want to really know where this will take us, because the Supreme Court did not also make any orders. It was just normal proceeding, and very many people don't know this legal, abracadabra. So people are thinking that the Supreme Court ought to have said, okay, you are bound by the judgment of the Court of Appeal and the Federal High Court.
Okay, first of all, let me say something. The argument that the Supreme Court didn't make any pronouncement on that suffers from poverty of logic and eclipse of legal reasoning.
Okay.
Because if you take a look at the provisions of Section 287 of the Constitution, the judgment of the Supreme Court binds the Court of Appeal and every other court.
Okay.
The judgment of the Court of Appeal binds every other court, and indeed every other person. Even the judgment of the Federal High Court binds every other person, and indeed can be enforced. So the Supreme Court need not make any statement. You know why? Because what you have done is that you have agreed to the judgment of the Court of Appeal. What else do you want the Supreme Court to do?
By not appealing.
Yes, by withdrawing your appeal.
Yes.
What you have
so
said.
You're no longer opposing that judgment.
No, that's exactly. So you don't expect the Supreme Court to make any statement on that again. I mean, there is a land issue between A and B.
Yeah.
B goes to a court.
Yeah.
Gets judgment.
Mm-hmm.
A appeals and go to the Court of Appeal. Loses at the Court of Appeal. Goes to the Supreme Court and goes to withdraw his appeal at the Supreme Court. What he has done is that he has said, I now want to be bound by the judgment of the State High Court and that of the Court of Appeal.
Okay.
So I do not know what any other person is expecting the Supreme Court to do, because you need not go to the Supreme Court. It's your right of appeal. You choose to exercise it. You also have a right to waive it.
Okay.
So what the governor has done, the governor has said, no, I don't think there's any merit in my appeal. So let me be bound by the judgment of the Court of Appeal.
And some say that the 2 million naira cost that was awarded against him, it's normal in, like they were wasting the time of the court. It doesn't have any implication as regards him withdrawing his appeal.
Well, costs. In legal practice, we always say cost follow events. Okay. I mean, if you have made the other party expend energy and resources and you brought him to court, and the court finds that your application has no merit, the court will naturally award cost against you. But you see, irrespective of whether cost was awarded against the governor or not, what we should be looking at is implication, because it would have still been possible that cost was not even awarded. So even if cost was not awarded, the question is, what is the implication of that withdrawal?
Okay, so
the implication of that withdrawal is that, number one, the governor has accepted that Right Honorable Martin Amaewhule is a speaker. The governor has accepted that he cannot make any request, nomination, or application to any other House of Assembly other than the one led by Right Honorable Martin Amaewhule. The governor has also accepted that he doesn't have the power to transfer or deal with the clerk of the House of Assembly. The governor has also accepted that the National Assembly cannot come to take over the activities of the Rivers State House of Assembly. The governor has also accepted that money standing to the credit of Rivers State House of Assembly should also be paid to the House of Assembly led by Right Honorable Martin Amaewhule. The governor has also accepted that he cannot obstruct the activities of the Rivers State House of Assembly led by Right Honorable Martin Amaewhule. So when you take a look, the governor also accepted that he spent 2024 monies without budgets. Okay. Now, that can never be spent. A constitutional breach can never be spent. Because, and I think we need to take this argument even beyond what the governor is doing. We now need to look at what the House of Assembly can do. Because it's not a thing, there is no ruling that the court will give in this regard. Okay. And that's why I'll tell you that in as much as the House of Assembly remains the bastion of democracy, when you have a House of Assembly tied to the apron strings of the governor, just know that you're going to have monumental corruption. Okay. Because you can still have a House of Assembly that doesn't back and doesn't bite, and the governor can spend money frivolously. Okay. Nothing would happen to him. Because if you go to court, what do you want the court to do? The governor has accepted that I spent money without budget, contrary to the provisions of Section 120 of the Constitution. Question, what would the House of Assembly do?
Exactly.
Because it's a gross misconduct. And I think this conversation should now shift beyond what the governor is doing to what the House of Assembly should do.
I was even going to ask that. Yes. What do you think? Don't you think that, considering what's going on, because 24 hours after this ruling by the Supreme Court, the governor also sent a list of some nominees for appointments, to the three-man assembly led by Victor Okojumbo. And then looks like, I want to do whatever I want to do, damning the consequences and all that. In this regard, what will the Rivers State House of Assembly under Martin Amaewhule do? Or is it going to just fold its hands and then say, well, the governor has refused to obey the judgment? Or will they have to go back to the courts?
Well, what the governor has done by spending money without appropriation law is actually gross misconduct. But like I said, the House of Assembly can choose to sleep on it. The House of Assembly can choose to act on it. Okay. And the conversations now should not even be whether the governor sends nomination to Okojumbo. That's not the argument. Because, you see, a criminal will continue to perpetuate his acts if the law does not hold him. Okay. So the argument we should do is not, why are you stealing? The argument we should do is, police, why are you not apprehending him and taking him to court?
Okay.
But in this instance now, the question we should ask the House of Assembly, in the light of what the governor has done, what are you going to do? Because, number one, to spend money without appropriation is gross misconduct. And there are a lot of authorities to that effect. So the House of Assembly can call the governor to give account and explain how he spent money without a budget.
Okay.
And that itself may now obviously lead to a new phase of the political crisis in Rivers State, which is actually impeachment.
Yeah, please, there's an aspect of this issue that I want you to, help us explain so that people will also understand. You see, the court said the matter had been dismissed.
Yes.
Sometimes we hear that a matter is struck out.
Yes.
What's actually the difference here?
Okay. When a matter is struck out, depending on the stage,
okay,
the other party can refer.
Okay.
When a matter is dismissed, also depending on the stage, your right of refiling that matter is abolished.
Okay.
No, but it depends on the stage of the proceedings. Where parties have filed their processes and contest the matter we had at the Supreme Court, where parties have filed their processes and you want to withdraw, that matter will be dismissed.
Oh.
Yes, it will be dismissed because parties have filed their processes.
And so the governor cannot refer.
You cannot refer.
In this particular case.
In this particular, the governor has accepted all that has transpired.
Okay.
So the governor does not have the right to appeal against the judgment of a matter show as enormous in the implications of that judgment. The governor has lost his right to appeal against that judgment today.
Wow. This is becoming very interesting. Godspower Egbule, public affairs analyst and then a legal practitioner in the Rivers State, has been with us in the studio and he's been doing justice to the today's topic. Well, we are still going to have him respond to one or two questions before we let him go. Don't go away as we are back. We're going to be right back. Thank you. I want to talk about defection.
Okay.
How about that?
Ask me.
Okay. Yes.
1, 2, action.
Yeah, Mr. Godspower, there's this issue. In fact, it was on one of the TV stations where we saw a highly respected senior advocate of Nigeria, Femi Falana, when he was talking about this matter. He said, well, that the judgment of Omotosho does not hold sway anymore because the 27 lawmakers led by Martin Amaewhule had defected after the judgment. And then this defection has become a recurring decimal. Some say because they defected, they no longer have the powers to order the governor. So please, can you shed more light on this issue? Tell us what actually happened and what we are expecting, if assuming the case is still in court or whether it's been actually thrashed.
Let me say this, that by virtue of Section 109 sub 1G, it says that a member of the House of Assembly loses his seat when he defects, when the provides so that there is no division in the political party that sponsored him. But you see, when you take a look at, and when you want to make interpretations with respect to constitutional provisions, you have to look at the Constitution in context. Section 109 must be read in context. Section 109 has sub 1, sub 2, and sub 3.
Yeah.
Section 109 sub 1G is not automatic, because you have to take a look at what Section 109 sub 2 says. Sub 2 says it is a speaker that is imbued with the right to declare a seat vacant.
Okay.
So until the speaker declares a seat vacant, you actually cannot say that someone has defected, because it's actually the power given to the Speaker of the House of Assembly, given to the President of the Senate, and given to the Speaker of the House of Representatives.
But in a situation where the Speaker also purportedly defected.
Now, the question is, the Speaker also defected, but that's an allegation, because I'm going to come to a judgment that dealt with this particular defection issue.
Okay.
Now, you are saying the Speaker defected. The principle of law is that when a statute had provided for a procedure or a method by which something can be done or should be done, no other method should be adopted to implement that thing.
Okay.
So if the Constitution has said there's a Speaker, and the Speaker has also resigned, according to some persons, no other person can declare that seat vacant. That itself presents us with another constitutional lacuna. So what do we do? I'll give you an example. By virtue of the Constitution, it is only members of the State Executive Council that can say the governor has become incapable of discharging the functions of his office.
That's what we had
basis of ill health.
During the time of Yaradua and all that. Yeah.
It is only members of the Executive Council.
Yeah.
Now, I usually ask questions about those who say Section 109 sub 2 shouldn't be tenable because the Speaker also resigned. Who appoints the commissioners who are members of the Executive Council? The governor.
Yeah.
Naturally speaking, would you expect those appointed by the governor to declare the governor incapable of discharging the functions of his office? In the event they don't do it, does anybody have that right to do it? No. Constitutional provisions must be respected. If you find that there are lacunas in the Constitution, all you need to do is go back to the legislature to make amends. And if you take a look at the historical antecedent of Section 109, you have to take a look at Section 103 of the 1979 Constitution, which also provided for the same provision you have in Section 109, which is about defection. Yeah. The challenge we had in the 1979 Constitution is that it didn't provide that it was a Speaker that was going to declare that seat.
Okay,
then it didn't provide.
Okay.
So if we're still practicing or using the 1979 Constitution, then it's tenable to say it's automatic. Okay. But now we have a 1999 Constitution that gives the power to the Speaker. Okay. So if the 1999 Constitution has given that power to the Speaker, no other person can exercise it.
Until that is also amended. That is done.
But you see, we also need to realize that this issue of defection is an allegation. Because even those who say they have defected have said they have not defected.
Yeah, but we saw them on TV, waving their flags at plenary and all that.
We practice an adversarial system of jurisprudence, which in civil matter, you have to prove. In civil or criminal, you have to prove. In civil, prove on the balance of probability. Then in a criminal matter, prove beyond reasonable doubt. So if you make an allegation, the burden is on you to prove. If someone says, I didn't defect, and you say you defected, you have the court to ventilate your grievances. But I will tell you, the judgment of the Court of Appeal delivered on the 13th of December 2024 actually also dealt with this issue of defection. If you take a look at page 74 of that judgment, the court said that alleged defection didn't exist. So when you still see people saying, they defected, and with the greatest deference to Femi Falana SAN, I wonder if he has read his judgment, because that judgment as of today is still standing. The court said that alleged defection did not occur. Page 74 of the Court of Appeal
which is also part of what the appeal of the appeal.
That appeal was relying on the appeal that dealt with the case of Honorable Justice Omotosho and the appeal that dealt with the judgment of Honorable Justice Wali.
Yes, I remember.
The Court of Appeal came and said, by virtue of these concurrent findings of these two courts, that alleged defection did not exist. Wow. So as of today, if you're still saying they defected, it's a personal opinion, because you have not presented it before the court. Now, even the case of Honorable Justice Omotosho, they still had the opportunity of presenting it to the court. You know why? When the governor presented the budget on the 12th of December 2023, on the 15th of December, Right Honorable Martin Amaewhule brought that to the notice of the court. Who is saying they defected on the 11th? Why didn't you bring it to the notice of the court? I mean, the court is not a scavenger that will leave, the Judas that sits in the court to now go and be scavenging
going on
for
a
facts.
Voyage,
no, it is you that will bring
discovery.
that evidence before the court. If you don't bring it before the court, what do you want the court to do? The court acts based on facts and applies the law to those facts. The fact as to whether they have defected is not before the court. You now went to the Court of Appeal and you raised it. The court said there is no sufficient evidence to back this allegation that they defected, and said there is no such defection. So I wonder people who still say they have defected. You say I have defected. I said I have not defected. I mean, you say my name is let's say you say my name is ABC, and I say no, my name is Godspower Egbule. It's enough for you to go to court and say no, your name is not Godspower Egbule.
With evidence.
With evidence and to show, oh, I have your BVN, I have your certificate, I have all of this presented before the court. You can't just say that I defected, and you have a forum for you to ventilate your grievances. You didn't utilize it.
Yeah, but there's also this case of sworn affidavits by the lawmakers. You know, I don't know what happened. The matter was in the court, and then along the line, I think it was withdrawn and all that. So some persons keep saying that they swore to an affidavit, which is also in public domain. I don't understand. Can you please shed more light on that?
You know, there are just certain comments I would not want to make with respect to this. You know, one is to not embarrass some persons. Because there are certain arguments that shouldn't be coming from lawyers. You talk about an affidavit. You can amend an affidavit.
Based on, I think, the evidence act.
You can amend an affidavit. You know, in any case, you must meet the requirements of the law. In the event you want to use an affidavit sworn in a different court in another court. You must meet some requirements.
Oh, really?
So the question now is, this document you're showing to the public, has a court decided on it? So if the court does not decide on it, what are you going to do with it? As of today, we have a judgment of the Court of Appeal that said they have not defected. So any other opinion that someone has is his main opinion, and the Constitution guarantees you the right to freely express yourself. But when you're done expressing yourself, the law stands.
So it's not about video evidence
you can have all of this video evidence and you're not able to present it before the court. You can have a video evidence. The Constitution, the Evidence Act in Section 84 tells you what you need to comply with to even bring that evidence before the court.
But I want to, there's something, you know, I need us to actually look at. Now, the issue of evidence of defection, and assuming that defection took place at plenary, we normally have the clerk who is supposed to have record of activities on that day. Now, the people who allege defection, for instance, the Edison Ehe, who said they had defected, he declared their seat vacant, which is why Okojombo is also relying on that. Was Edison involved that day, and then was he the speaker, and does he also have access to the records of activities on that same day? Because I'm beginning to wonder, doesn't the clerk have a role to play in this?
Well, you know that at some point the governor now moved the sitting of the House of Assembly to Government House. But the appointment of the clerk rests squarely with the House of Assembly. So whatever the governor is doing just tells you it's in contravention of the law. Then with respect to the video evidence and the other things that you have stated, is it the practice of the law and the provisions of the law is that the best evidence as to show what actually happened in the House of Assembly is the Hansard, which records every other thing. Now, beyond recording every other thing, you will need to present it before the courts. And also do not forget that everything that Edison Ehe did was nullified by the judgment of Honorable Justice Omotosho delivered on the 22nd day of January.
But he got a judgment from, or some kind of ruling or judgment from Justice Danagogo.
I have made commentaries on that. I have seen that order. There is nowhere in that order where Edison was declared as a speaker.
Rather.
Nothing in that order declares Edison as speaker. In any case, the entire thing that Edison did was nullified by Honorable Justice Omotosho. Because Edison was also a party to that suit before he resigned his membership of the House of Assembly.
And
if you say, no, it wasn't Edison, it's the governor that withdrew. Edison resigned and automatically he lost being a party to that suit because his party to that suit is because he's a member of the House of Assembly. Now, in any case, you say you've got an order of court and there's another proceeding going on. You had the opportunity of presenting that your order you had before Honorable Justice Omotosho, but because you know there is nothing in that order telling you that you're the speaker, you obviously will not present it before the court. You can't present that order that Honorable Justice Danagogo gave, and you said this order made you the speaker. You know why? By the provisions of the Constitution, Section 92. I hope I'm not. I'm sure Section 92 of the Constitution provides how the speaker and deputy speaker will be elected. And the Constitution also provides procedure for removal of a speaker and deputy speaker.
Okay.
The election of a speaker is by majority, but the removal of a speaker is by two-thirds majority.
Okay.
So it is simple to elect a speaker, but difficult to remove him.
Oh, really?
Very difficult. You have to have two-thirds majority. So the question we should put out is, was there any time that Edison here had two-thirds majority to remove Right Honorable Martin Amaewhule-led? Because the courts will never make you a speaker.
Oh, really?
The court will never make you a speaker.
It's not about the declaration
No,
of...
no court will make you a speaker, because the constitutional provision, you have to be elected by your fellow members of the House of Assembly.
Okay.
But for them to remove you, they will need two-thirds majority.
Okay.
And so nobody can go. It's just like me going to court and say, "Court, please declare me I am the governor of Rivers State."
Okay.
You didn't contest an election. Does the court make someone a governor? No. Except someone disputes that election that brought you in and can present evidence to show that he won the election. You didn't participate in an election. You didn't go to tribunal. You now say you should be declared. Imagine somebody now parades himself as governor of Rivers State. That's exactly these same persons are doing by saying they are speakers of the Rivers State House of Assembly. No court can make you speaker. Speakership is by the Constitution. And the Constitution did not contemplate faction. And let me also say this, and I say this to journalists, because we have a great role to play.
Yeah.
You know, when you call someone factional speaker, what you're doing is that you're laying credence to the person's status. A court has said this person is not.
Yeah.
And you are also saying factional, because a lot of times I see media houses, they do that. It is wrong. We have to now learn how to respect judgments of courts.
Okay.
We have to respect, if the court has
And not
said,
to cherry pick.
no.
No.
There is not, the Constitution did not contemplate a faction. So it's either you say, Right Honorable Martin Amaewhule is the Speaker of the Rivers State House of Assembly, or you say he's not.
Okay.
But if he is, then there can be no person to be addressed as the Speaker of the Rivers State House of Assembly.
Wow, this is very interesting. But on a final note, what do you think is the way forward in all of this?
Well, for political...
What does it portend for the state?
What this other issue as to what it will portend raises a different dimension.
Okay.
But, the way forward is very simple.
Okay.
Political actors must learn to abide by the law and decisions of the law, you know, and not fanning sentiments, because sentiments may stay for some time, but at the end of the day, it will just whittle down. Then, as to what it portends, very simple. The governor is the governor. He's saying he's the governor. The House of Assembly is the House of Assembly. They too will show that they are members of the House of Assembly. They have powers. The unfortunate thing that has happened is that I'm not sure the governor realizes the enormous powers of the House of Assembly.
Okay.
I'm not sure he does. Because if he does, you would know that no governor can succeed without the House of Assembly. You obviously cannot.
Wow.
And any governor you see complaining too much about the House of Assembly, just know that that governor is saying that the House of Assembly is not giving him the opportunity to pilfer most times, to commit wrongs. Because what would the legislature do? The power of the legislature to remove you is to the extent that you have committed gross misconduct. So if you have not committed gross misconduct, you cannot be afraid of the legislature. Even if it's the easiest thing to do in terms of the seat of the governor and that of the legislature, easier to remove a governor. Very easy by constitutional provision. But you see, the legislature cannot just wake up one day to remove you if you have not committed infraction. So for the governor should now begin to think of how to maneuver himself with respect to the constitutional infractions that he has committed. For me, that's the next phase of what is going to happen to Rivers. And again, there should be no emotions about it.
Okay.
There should be no emotions about it. Because too often we talk law rather than a lot of people portray fanciful emotions rather than law.
No.
But we should take a look at what the law has said, irrespective of who's also the God.
Wow. Thank you very much, Godspower Egbule. We're delighted to have you on the show today. It's been quite sizzling, educative, informative, and I think that with what you've done today, a lot of persons will begin to reconsider their position and all that. I also spoke with somebody recently, and I found out that he was defending the governor based on his little knowledge of the issues, at hand. But, well, everybody has their opinion. But at the end of the day, like you said, it is the law that will stand. Thank you. Have a wonderful day.
Thank you.
God bless you.
My pleasure always being here. Thank you.
So, we are done with today's episode, and I hope you're going to continue to subscribe, like, share, and comment. Thank you.